Welcome to the Rozanne On Demand CFPB video series, featuring Ontario System's Chief Compliance Officer, Rozanne Anderson. Widely recognized as a leading authority on collection-related compliance, Rozanne leads Ontario System's corporate efforts in response to the CFPB's launch of compliance examinations in the ARM industry. In this ongoing video series, Rozanne takes a deeper dive into the entire regulation, helping you make sense of the new rule and what it means for your agency. Before we get started, please take a moment to review our legal disclaimer. The information shared today is not legal advice. Please consult with your own independent legal counsel before making any business decisions regarding the use of this information.
Welcome to Ontario System's video podcast series covering the new rule for debt collection. Today, we will be exploring the requirements of email communications. Most specifically, how you obtain an email address to communicate with consumers about a particular debt. Now, before we get into the details of email communications, what we all have to appreciate is that the CFPB did offer debt collectors a safe harbor when it comes to email or text communications. What I mean by that is if the debt collector chooses to follow the requirements of the new rule with regard to email communications or text, you will be protected from any claim by a consumer that the email or the text divulged or disclosed the existence of a debt to a third party. In other words, it's a safety net. You need not comply or choose to take advantage of this safety net, but if you do, you will have a bona fide defense against a claim for disclosing the existence of a debt to a third party because you either used the wrong email address or used the wrong mobile number. So let's talk about email requirements. Let's assume also that you do choose to take advantage of the safe harbor provisions. There are actually 3 ways to obtain an email address under the new rule. Regardless of the way that you choose, the protections afforded you under the new rule only extend to a debt, a particular debt. We are not talking about the kind of blanket consent you may be interested in obtaining to communicate with a consumer electronically about any debt now or in the future. So let's keep that in mind as we go through the requirements. The first process you may follow in order to obtain an email address to communicate about the debt or a debt is if the consumer actually uses a particular email address to communicate with you, the debt collector, first. So if they initiate the contact, if they use an email address to communicate with you, and you may in turn use that email address to communicate with them about the debt until they opt out. So consumer initiated about the debt, you may reply using that email address about the debt. Number 2, if the debt collector actually received prior consent directly from the consumer to use the email address, then the debt collector may use that email address to communicate with the consumer about the debt. So either the consumer initiated it and used the email, or you obtain the direct consent from the consumer to use that email to communicate about the debt. Does that mean this does not extend to email addresses you may have had passed down to you from the creditor, as you may use today? And the answer is no, you cannot use creditor email addresses or email addresses obtained by creditors when communicating about the debt unless you follow a very, very specific series of steps. This brings us to the second method you may use to obtain an email address to communicate with a consumer about the debt. And that is when the creditor did obtain direct consent from the consumer to use an email to communicate with them about the account For example, they may have communicated, they provided a statement to the consumer or information about a late charge or in a variety of email topics that could have taken place between the original creditor and the consumer, other than advertising or marketing. So if the creditor obtained the email address from the consumer and used it in connection with the account while it was in possession, the creditor's possession, then if the creditor does a few things, including send a handoff letter to the consumer, the debt collector may use that email address. So let's take a look at exactly what must a creditor do in order to afford you the opportunity to use that email address. I mentioned the fact that the creditor could send the consumer a particular letter. Now, this letter could be sent electronically or in a paper format. And this is an example of the content that the CFPB has authorized for that letter. We are transferring your account to ABC Debt Collector, and we are providing ABC Debt Collector with the following email address for you. So number one, they have to identify the debt collector to which they are assigning the account by name. Number two, they have to actually include the email address they are going to share with the debt collector and include that in their letter or electronic notice. Next, the letter must contain the statement, and such debt collector may use this email address to communicate with you about the debt. If others have access to this email address, then it is possible they may see the emails. If you would like to opt out of communications by that debt collector using this particular email address, then please fill out the enclosed form and return it in the enclosed envelope so that we may receive it by a certain date. Now remember, they may send it electronically as well, using, for example, the very email address they are going to share with the debt collector. However, what you must be mindful of is that the couple of other details. The creditor, when sending this notice, not only has to identify the debt collector by name and include the email address specifically in this notice, but they also have to provide the consumer with a minimum of 35 days to opt out of this process, which means from the day that the creditor decides to charge off the account and then forward it out for assignment to the debt collector, they should consider the fact that there has to be a 35-day waiting period for the consumer to opt out. And the consumer could either opt out to the creditor or to the subsequent debt collector, but they need not opt out to both. But remember, they have at least 35 days to do so. In the supplement to the new rule, the CFPB actually outlines in great detail the content of the letter I just referred to, as well as the electronic version of that notice. Please note that with regard to the creditor handoff letter, the debt collector may send a consumer an email if the email address has a domain name that is available for use by the general public, unless the debt collector knows the address is provided by the consumer's employer. This requirement to not use an email address the collector knows to have been provided by the employer only applies when seeking safe harbor protection using the creditor handoff notice at section 1006 D4. The third way a debt collector may obtain an email address to use in connection with the collection of a debt, a particular debt, would be based on prior debt collector consumer communications. Now, this particular option is a bit tricky, but it may be advantageous to certain types of debt buyers, particularly if they are a tertiary or a quad debt collector in terms of the order in which the account was assigned, or if they are a debt purchaser. So let's take a look at what does the third option look like. Well, the CFPB tells us that any prior debt collector who obtained the email address from the consumer using one of those first two options I just described, and if the immediately prior debt collector in fact uses that email address to communicate with the consumer about the debt and the consumer did not opt out, then the immediately subsequent debt collector may use that email address. So what does this not mean? Assuming the creditor obtained the email address, from the consumer, or the consumer provided a prior debt collector with consent to use their email address about the debt, or they directly communicated with one of the upstream debt collectors about the debt using a particular email address. In any of those cases, we now have an email address that qualifies for part one of the third way you can obtain an email address, because it was properly obtained in the first instance. Now the creditor can continue to pass that email address downstream to various debt collectors. But this is the catch. If the creditor, let's say, obtained the email properly, passed it on to the initial debt collection agency in the sequence, and that debt collector did not use the email address to communicate with the consumer, then that means that the secondary debt collector cannot use the email either. We have to make sure that the immediately prior debt collector used that email address that was properly obtained to communicate about the debt. Then the immediately following debt collector can use it. So it's possible that there could be some breaks in the chain that would disqualify a subsequent debt collector from using that email address, but a tight alignment between the debt collector or the debt buyer and the client will help you determine if this third option is amenable to your debt collection practice. Thank you for joining us today.
Please be sure to join us next week for episode 5, where Rozanne will walk us through the safe harbor requirements for text messaging under Regulation F. Be sure to visit the Ontario Systems website for more exclusive events and information regarding the 2021 CFPB new rules.